Ashwini Vaishnav has said that the industry will get 2 years to comply with the new data protection rules. This as the rules aim to implement a slew of measures on all data fiduciaries, including government enterprises. Ashmit is here to take us through the top takeaways from the bill. Ashmit.
The Parliament passed the DPDP Act in August of 2023, and since then the industry, rights activists and even everyday digital beings like you and I have been clamoring for implementation. And finally, 16 months later, we have the draft DPDP rules. So what are the major takeaways? Well, first, the government has championed a consent-based approach for the DPDP rules. The word consent has been used 56 times in the draft and is the third most used noun after data and fiduciary. Now, companies seeking personal data will have to seek your consent. The consent notification should be clear and simple and will have to disclose what details are being sought. So over the next few months, should this draft go through, expect a flurry of notifications asking you for your consent. And therein lies the worry about consent fatigue. Basically, one may end up blindly clicking on yes on every notification. Second, if you are worried about consent fatigue, well, the DPDP Act and the rules provide for a consent manager. An entity or a person acting as a consent manager can help you give, withdraw or manage consent to companies, to social media platforms. The consent managers will have to be registered with the Data Protection Board. Third, while Australia may have banned social media for kids entirely, the Indian government has taken a qualitatively different approach by introducing parental consent. Companies collecting personal data of children below the age of 18 will require parental consent. Parents will have to be verified as well using digital IDs. But this issue alone has the industry in a fix on going about implementing such a mechanism. Also, they're quick to point out loopholes like, for instance, there is no rule for verifying the age that a child may self-declare, for example, on a social media company. Fourth, compliance burden. Entities collecting data have to deploy reasonable security safeguards, inform users in case of a breach, appoint a data protection officer, and deploy a grievance redressal system. In an exclusive conversation, Ashwini Vaishnav told us that he does not want compliance to stifle innovation like in Europe. Fifth, the rules codify rights of individual users. We will have the right to give or withdraw consent. You will also have the right to be informed in case of a breach. Once the purpose of your personal data is concluded, the data needs to be deleted. You can also seek clarity on data that has been collected by a company or entity. You also have the right to a grievance redressal system. And finally, sixth, through these rules, the government has granted an exemption for all government entities that provide subsidies, benefits, licenses and permits, which would cover a large share of government entities. Not just that, the government has also given itself the power to call for personal data from any entity in case of national security. So clearly, a lot to unpack there. The government has clarified that it will allow a 2-year window for the industry to fully comply. For now, the draft rules are open for public comments till February 18th.